In this lesson, we're continuing our discussion of subject matter jurisdiction. Specifically, we're going to focus on diversity jurisdiction. But if we think back to our basic requirements, remember at a really broad level, we say to hear and decide a case before it, a court generally must have subject matter jurisdiction over the particular type of case before it, personal jurisdiction over the defendant, and proper venue based on locality. Of course, in this lesson, we're focused in on this first basic requirement, and we're really thinking about federal subject matter jurisdiction. Basically, whether the case before this federal court is the type of case that a federal court can hear and decide. Here we say, other than subject matters exclusively allocated to federal courts by law, remember we talked about these as things like admiralty, maritime, patent, copyright, bankruptcy cases. Other than these types of cases that are exclusively allocated to the federal courts by federal law, there are generally four main ways for a federal court to obtain subject matter jurisdiction over a case. In our last lesson, we talked about federal question jurisdiction. Remaining, we have diversity jurisdiction, supplemental jurisdiction, and removal. Of course, in this lesson, we're going to focus on diversity jurisdiction as a means of a federal court obtaining subject matter jurisdiction. Here for diversity jurisdiction, we say under 28 U.S. Code, Section 1332, a federal court has diversity jurisdiction if complete diversity is present and the amount in controversy exceeds $75,000. Okay, in this lesson, we're really going to focus in more so on this first element, the complete diversity requirement. In our next lesson, we'll get into the amount in controversy requirement in more detail. But let's just go over them both at a really broad level so we know where we're going. So if we think about complete diversity, we're really thinking about the citizenship of each party to the lawsuit. We're asking, where are the plaintiff's citizens and where are the defendant's citizens? Are they diverse? Does any plaintiff share any citizenship with any defendant? If so, they are not diverse. If a plaintiff is from the state, or if a plaintiff is a citizen of the state of Texas and a defendant is a citizen of the state of Texas, then they are not diverse. They share citizenship. Okay, now if we have a plaintiff who is a citizen of the state of Texas and a defendant who is a citizen of the state of Florida, they are diverse. None of our plaintiffs share any citizenship with any of our defendants. Okay, that's what we're thinking about with complete diversity. We're thinking about the citizenship of our plaintiffs and we're thinking about the citizenship of our defendants. We're going to break down all the nuances of this as we work through this lesson, but that's the big picture idea. In terms of the amount in controversy, this is really just the monetary value at stake in a lawsuit. Oftentimes, this is very straightforward. If we have a plaintiff suing a defendant in torts for negligence and they're seeking $100,000 in monetary damages, okay, the amount in controversy is $100,000. This is usually the monetary value of the damages being sought by the plaintiff. We'll see this can get nuanced, right? You could have a plaintiff seeking non-monetary damages. We could have a plaintiff seeking equitable relief. What do you do when the plaintiff is seeking an injunction? These are things we'll get into in our next lesson. But for now, we can accept the amount in controversy is the monetary value at stake in the lawsuit. This is generally the monetary value of the damages the plaintiff is seeking. Okay, but again, in this lesson, we're really going to focus on this diversity requirement. So we can just jump right into it with a few basic examples first. I find with diversity jurisdiction, the best way to kind of understand this concept is just to work through a lot of examples. So throughout this lesson, we're going to work through a lot of these practice problems. So we can start with our first one. This is a very easy one just to illustrate the main concepts. Okay, here we have the following practice problem. Pam is injured in a car accident as a result of Doug's negligence. Pam is a citizen of Texas and Doug is a citizen of Florida. Pam brings a state law tort claim against Doug in federal court seeking $100,000 in damages. Does the court have subject matter jurisdiction over the case? So this is a review of everything we've talked about thus far in our lessons on subject matter jurisdiction. What do we do if we're looking at a law school exam, bar exam, and we're being asked, does the court have subject matter jurisdiction? Well, the first question is this a state court or a federal court? Because remember, state courts have more unlimited subject matter jurisdiction. State courts can hear a lot more types of cases than federal courts. Well, here we know Pam is bringing the action in federal court. So we have to think, okay, well, how does a federal court obtain subject matter jurisdiction? Remember, federal courts have more limited subject matter jurisdiction. Federal courts are more limited in the types of cases they can hear. We know sometimes federal law allocates certain types of cases to federal courts exclusively. These are things like copyright cases, patent cases, bankruptcy cases. Well, we don't have one of those here. This is a state law tort claim. So we don't have a copyright case or a patent case, something that's been exclusively allocated to the federal courts. So what are other ways a federal court can obtain subject matter jurisdiction? Well, we have our big four. Remember, we just went over that in a prior slide. There's federal question jurisdiction, diversity jurisdiction, supplemental jurisdiction, and removal. On a law school or bar exam fact pattern, we always want to start with federal question and diversity. These are the big two main ways a federal court obtains subject matter jurisdiction. Supplemental jurisdiction and removal are more kind of ancillary special issues we're going to get into in future lessons. So let's just kind of ignore those for now because they're not an issue here. And let's just think about federal question and diversity for a second. Okay, because these are kind of the two main ways a federal court is going to obtain subject matter jurisdiction over a case. Well, here we see Pam is bringing a state law tort claim against Doug in federal court. Okay, so does the federal court have federal question jurisdiction over this case? This is a review of our last lesson. Remember, for a federal court to have federal question jurisdiction over a case, the cause of action must arise under federal law pursuant to Section 1331. Okay, so here we have a state law tort claim. A state law tort claim does not have that federal ingredient we need in the lawsuit. This state law tort claim does not arise under federal law. So the federal court is not going to have federal question jurisdiction over this case. So what's the other way a federal court can obtain subject matter jurisdiction over a case? Well, we have diversity jurisdiction, which we're getting into in this lesson. Remember, what are the requirements for diversity jurisdiction? We need complete diversity between the parties, and we need the amount in controversy to exceed $75,000. Do we have that here? Well, Pam is a citizen of Texas, and Doug is a citizen of Florida. Okay, so no plaintiff shares citizenship with any defendant. Right? Our plaintiff and our defendant are diverse. Complete diversity is satisfied. And if we look at this little diagram we have here on the slide, this is how I would recommend doing it on the law school exam or the bar exam. If you're trying to determine whether there's complete diversity between the parties, I would diagram it just like this. I would draw an arrow, and I would put all of my plaintiffs on the left side of that arrow, and I would put all of my defendants on the right side of that arrow. And I would put their citizenships right next to their names, or how we have it here, like P1 is from Texas. If we had multiple plaintiffs, you could go P1 is from Texas, P2 is a citizen of Florida, P3 is a citizen of New York, whatever. Then you draw your arrow, and then you do your defendants. Defendant is a citizen, defendant 1 is a citizen of Florida, defendant 2 is a citizen of New York, whatever, right? And you just draw it out, and then you basically just play a matching game, right? Does any of the citizenships on the left side of the arrow match any of the citizenships on the right side of the arrow? If so, you do not have complete diversity. That means a plaintiff shares citizenship with a defendant. They are not diverse. Okay, so I would draw it up. I would put them down on either side of the arrow, and I'd play a matching game. That's the best way to analyze diversity. I know it's elementary, but it's infallible, right? As long as we're marking it correct, as long as we have the right citizenship of each party and we write it down correctly and we do the matching correctly, we should always get that right. Okay, so that's complete diversity, and it is satisfied here. We only have two parties. We have one plaintiff and one defendant. The plaintiff does not share citizenship with the defendant. Plaintiff is a citizen of Texas, defendant is a citizen of Florida, so we have complete diversity. The amount in controversy is given to us. Pam is seeking $100,000 in damages. $100,000 exceeds the amount in controversy requirement of $75,000. So in this fact pattern, the federal court could exercise subject matter jurisdiction over this case pursuant to Section 1332 diversity jurisdiction because they have complete diversity between the parties and the amount in controversy exceeds $75,000. Okay, that's practice problem one. Let's do another one. Okay, this is basically the same thing. We're just adding another plaintiff. Let's see how this affects the analysis. Here, Pam and Paul are injured in a car accident as a result of Doug's negligence. Pam is a citizen of Texas, Paul is a citizen of Florida, and Doug is a citizen of Florida. Pam and Paul bring a state law tort claim against Doug in federal court seeking $100,000 in damages. Does the court have subject matter jurisdiction over the case? Well, remember, we're dealing with a federal court. Federal courts have limited subject matter jurisdiction. What are the ways a federal court can obtain subject matter jurisdiction? The big two are federal question and diversity. We don't have federal question here. It's a state law claim. There's no federal law ingredient. The state law claim does not arise under federal law. So then we go to diversity jurisdiction. Well, does the court have diversity jurisdiction to hear this case? And here we actually diagram it up. So we put all of our plaintiffs on the left side of the arrow, and let's put all of our defendants on the right side of the arrow. So if we draw it up like it is on the slide, we see we have a plaintiff we have a plaintiff who is a citizen of Texas. We have another plaintiff who's a citizen of Florida suing a defendant who is also a citizen of Florida. So here, even though Pam and Doug are citizens of different states, our second plaintiff, Paul, shares citizenship with our defendant, Doug. Therefore, complete diversity is destroyed because we have a plaintiff who shares citizenship with a defendant. We do not have complete diversity, okay? And if we look on the left side of our arrow and the right side of our arrow, we see we have a match, right? And I've color coded it. It's this teal highlighter color. Since we have basically that teal color on the left side of the arrow and on the right side of the arrow, we know P2, our second plaintiff, and our defendant share citizenship. There is no complete diversity between the parties pursuant to Section 1332. Okay, and if you have highlighters available on your test, you could do this as well. You can do it with circles, with shapes, with underlines. If you have highlighters, you can color code each state. You can be like, Texas is going to be yellow and Florida is going to be blue. And you write them all down and then you can highlight. And then you just see, do I have two of the same color on both sides of the arrow? If so, I know citizenship is shared. I don't have complete diversity between parties. So a lot of ways you can diagram it however you want, but please do diagram it. Some of these, the anatomies of these lawsuits can get complex. So if you try and do it in your head, sometimes it's easy to mix it up. So you always want to write it down like we have it here. Okay, if we do this, we should be in pretty good shape as long as we're getting the citizenships correct of each party. Okay, but these are some really simple, just big picture examples so we kind of see where we're going. Now we need to actually break down 28 U.S. Code 1332A in a little bit more detail. We'll see 1332A actually has 4 subsections. We have 1332A1, A2, A3, and A4, and they all kind of deal with slightly different fact patterns. So what we just went over is a situation where all of the parties in our lawsuit are citizens of the United States. They're citizens of states within the United States. That's kind of the most classic fact pattern, and that's 1332A1. 1332A2, A3, and A4 deal with the situation where we have basically a foreign party in the lawsuit. And we'll kind of go through each one of these subsections and examples on how to deal with it. But again, usually if we're dealing with citizens of the United States. We have a citizen of Texas suing a citizen of Florida. It's just 1332A1. It's kind of what we just did. And that's probably your most classic example, but we do want to know how to deal with fact patterns if we have foreign parties. If we have a citizen of Mexico or Canada involved, what do? That's what we're going to break down here. Okay, so under 28 U.S. Code Section 1332A, complete diversity exists when, at the time the complaint is filed, the action is between citizens of different U.S. states, that's what we just did, citizens of a U.S. state, and citizens of a foreign state, absent the permanent residence exception, U.S. citizens of different U.S. states, and in which citizens of a foreign state are additional parties, and a foreign state as plaintiff, and citizens of a U.S. state or of different states. Again, we're going to break all these down. I know that's a lot of words. We'll go through each one of these subsections with examples. Okay, but before we jump into that, one other important note to make here is just a timing issue. If we think about this, under 28 U.S. Code Section 1332A, complete diversity exists when at the time the complaint is filed, the action is between citizens of different U.S. states, etc. Okay, so what we're going to find as we work through examples is it's possible that the citizenship of a party can change during our fact pattern. And don't worry about how that happens. We're going to cover that in a few minutes when we get further along in this lesson. But just know it's possible that a person's citizenship can change. You know, one way just to have an example in your head is if you move. If a person lives with an intent to remain indefinitely in the state of Texas and they move with an intent to remain indefinitely, they move their physical location to Florida, and their intent is to remain indefinitely in Florida, we'll see that person's citizenship has actually changed from Texas to Florida. Okay, and so what can happen sometimes in these fact patterns is a person, say, might be a citizen of Texas when the actions that give rise to the lawsuit occur, but by the time the action's actually filed, when that complaint is filed, the party's citizenship has changed. Maybe they've moved. Maybe something else has happened. They were a citizen of Texas when the actions that gave rise to the lawsuit occurred, but when the complaint is filed, now they're a citizen of Florida. Well, for our purposes in determining whether complete diversity exists, we look at the citizenship of the parties at the time the complaint is filed. This is very important. We don't want to get confused by this. I promise you'll see it tested, whether it's in law school or the bar exam. Eventually, this will be tested. It's one of those issues that's just ripe for testing. Okay, so when we're determining citizenship, and we're going to see how we determine citizenship in a few minutes when we get to these future slides. But when we're determining citizenship, we're always determining citizenship at the time the complaint is filed. Not when the actions that gave rise to the lawsuit occurred, not when the car accident happened. It doesn't matter who was a citizen of where. When the car accident happens, when the actions that give rise to the lawsuit occur, it's because we know that car accident could happen, 2 years could pass, people have moved all over the place, citizenships have changed. The action actually gets filed for 2 years later. That's when we look at the citizenship of each party and that complaint is filed. Okay, let's break each of these subsections down. Let's look at 1332A and let's break each subsection down, starting with complete diversity under section 1332A1. This is what we've talked about kind of thus far. Complete diversity exists when at the time the complaint is filed, the action is between citizens of different U.S. states. Okay, so this is the fact pattern where we do not have a foreign party involved. Basically, every party to our lawsuit is a citizen of the United States, is a citizen of some state basically within the United States. This is what we've been talking about thus far. Okay, so let's look at this first example we kind of have drawn up. We have 3 plaintiffs suing 2 defendants in federal court. Okay, we have 2 plaintiffs from Texas and 1 plaintiff from Pennsylvania suing 2 defendants from Florida. Does complete diversity exist? Well, we just play the matching game. Does any plaintiff share citizenship with any defendant? Answer is no, right? We have two plaintiffs that share citizenship and two defendants that share citizenship. That doesn't matter. None of our plaintiffs share citizenship with any of our defendants. Basically, all the citizenships represented on the plaintiff side of the case are different than the citizenships represented on the defendant side of the case, so complete diversity exists. Okay, let's change this slightly. Let's say our third plaintiff is actually a dual citizen. We'll see with corporations, like a corporation has dual citizenship. It's a citizen of two places concurrently, two U.S. states at the same time. This is very possible for corporations. We'll see that corporations are a citizen where they're incorporated, state of incorporation, plus their principal place of business. We're going to talk about this in a minute, but basically corporations have dual citizenship. So our third plaintiff, let's say here, is a dual citizen of both Pennsylvania and Florida. Let's say all the other citizenships stay the same. Now, do we have complete diversity? The answer is no, right? We have shared citizenship between the plaintiff side of the case and the defendant side of the case. Our third plaintiff is a citizen of Florida. Both of our defendants are a citizen of Florida. So there is no diversity between that third plaintiff and our defendants. That third plaintiff's dual citizenship in Florida destroys complete diversity. Basically, we have a plaintiff who shares citizenship with a defendant. Turns out it's both defendants in this case. Okay, so there's no diversity. Okay, and it doesn't matter. We could have 100 plaintiffs and 100 defendants, and 99 of the 100 plaintiffs and defendants could be completely diverse. If there's one party who is not diverse, it destroys it for everyone. The whole lawsuit, basically. There's no complete diversity. It's like an all or nothing kind of rule. Okay, so because we have a plaintiff who shares citizenship with any of the defendants, complete diversity is destroyed. This is 1332A1. The key is just diagramming it correctly. We want our plaintiffs on the left side, our defendants on the right side of the arrow, and then we play our matching game. Okay, let's go to 1332A2, complete diversity under section 1332A2. This is where we start to get foreign parties involved in the lawsuit. What do we do? Complete diversity exists when at the time the complaint is filed, the action is between citizens of a U.S. state and citizens of a foreign state. However, if a foreign party is a lawful permanent resident of the United States and is domiciled in the same U.S. state that any opposing party is a U.S. citizen, then the federal court cannot exercise diversity jurisdiction. Okay, so let's look at a basic example here, and then we can add some nuance. Let's say we have a plaintiff who is a citizen of Texas suing a defendant who is a citizen of Mexico. Do we have complete diversity? The answer here is yes. This whole part about a foreign party being a lawful permanent resident does not apply here. Our defendant from Mexico is not a lawful permanent resident of the United States. So if we have a party who is foreign, right? They're a citizen of another country, but they are not lawfully permitted residents of the United States, the analysis is very easy. Then we have diversity. If we have citizens of the United States as opposing parties, as citizens of foreign countries, like we have here a plaintiff, a citizen of Texas, suing a defendant, a citizen of Mexico, and those foreign parties are not admitted for lawful permanent resident status in the United States, then we just do our matching game. It's very easy. Okay, yeah, we have a plaintiff from who's a citizen of Texas and a defendant who is a citizen of Mexico. They are diverse. None of our plaintiffs share citizenship with any of our defendants. Complete diversity exists. So this is actually pretty straightforward when our foreign parties do not have lawful permanent resident status in the United States. Okay, it gets more difficult when we see that the foreign party has lawful permanent resident status and they're domiciled in a U.S. state. Domicile just means it's a place where a person lives with the intent to remain indefinitely. Okay, so wherever you're living right now, wherever your physical location is, whatever state that is in, where you, as long as you concurrently have the intent to remain there indefinitely, then that's your state of domicile. It's basically where you live with the intent to remain indefinitely. Okay, so let's deal with a fact pattern where we have a foreign party who does have lawful permanent resident status in the United States. So what happens here? So Pam and Doug enter into a contract, and Doug breaches the contract. Pam is a citizen of Texas, and Doug is a citizen of Mexico. Doug has been lawfully admitted for permanent residence in the United States and is domiciled in Florida. Pam brings a state law breach of contract claim against Doug in federal court. Does complete diversity exist between the parties? Well, let's diagram it out. Okay, so we have a plaintiff who's a citizen of Texas suing a defendant who is a citizen of Mexico who has lawful permanent resident status in the United States but is domiciled in Florida. Do we have complete diversity? The answer here is going to be yes. Here, complete diversity exists because the action is between citizens of a U.S. state and a citizen of a foreign state. The permanent resident exception does apply, but that permanent residence is actually in Florida. He's domiciled here. Doug is a permanent resident, but he's domiciled in Florida, which is diverse from Texas. So our exception is triggered, but it's okay because the place of domicile is different than the U.S. citizen. Basically, our U.S. citizen is a citizen of Texas, and our lawful permanent resident from Mexico is domiciled in Florida. So we have complete diversity. So the exception is triggered, but it's okay because our defendant from Mexico is domiciled in a different state than where our plaintiff is a citizen. Hopefully that makes sense. Again, lawful permanent resident status is triggered, but it's okay because our foreign party here from Mexico is domiciled in a different state than where our U.S. citizen is a citizen, right, in Texas. I know it's a little bit confusing, but we can change it and see here. Okay, if we just change basically where that defendant from Mexico is domiciled, so they're still a lawful permanent resident, but now say they are domiciled in Texas, well, that's going to destroy complete diversity. This practice problem is the exact same. We've just changed where Doug is domiciled. Doug is a citizen of Mexico, but he is a permanent resident. He has permanent resident legal status in the United States, but now he's domiciled in Texas. That's where the exception destroys diversity, right here. Okay, so this is what we want to look out for. Like, this is the big exception of 1332A, this fact pattern. Pam and Doug enter into a contract and Doug breaches the contract. Pam is a citizen of Texas and Doug is a citizen of Mexico. Doug has been lawfully admitted for permanent residence in the United States and is domiciled in Texas. Pam brings a state law breach of contract claim against Doug in federal court. Does complete diversity exist between the parties? No, right? Even though our defendant here is a foreign defendant, right? He's a citizen of Mexico. He has that permanent legal resident status in the United States and he's domiciled in Texas, which is the same place our plaintiff is a citizen. So because that place of domicile for our legal resident in the United States is the same as the citizenship of our U.S. citizen, that destroys diversity. Okay, that's 1332A2. If you want more examples, you can follow along in the outline. You can see in the upper right what section in the outline this is. Breaks it down with some more examples. I think, though, if you kind of watch this back and look at those definitions, it will become clear. Next subsection is 1332A3, okay? So this is basically the same scenario that we just had, except the foreign party is actually now an additional party. If the foreign party is an additional party, that exception we just applied does not get applied. Okay, so this is how it works. Complete diversity exists when at the time the complaint is filed, the action is between U.S. citizens of different U.S. states and in which citizens of a foreign state are additional parties. Under Section 1332A3, the permanent residence exception from 1332A2 does not apply if the foreign parties are additional parties in an action between U.S. citizens of different U.S. states. Okay, so let's look at an example here. Practice problem 3.0 on section 1332A3. Pam is a citizen of Texas. Doug is a citizen of Florida. And Debbie is a citizen of Mexico. So you see how right there, basically Debbie, our person from Mexico, is like a third wheel. That's what we mean by additional party, right? We have already these two citizens from Texas or from the United States who are going to be suing each other, right? We have a citizen of Texas and we have a citizen of Florida. Pam, we know, is going to be our plaintiff. Doug's going to be our defendant. Pam is going to be suing Doug. So we have two U.S. citizens from different states suing each other. And then we have this third wheel, Debbie, who's from Mexico. That's what we mean by the foreign party is an additional party. It's like that third wheel situation. Okay, let's continue the fact pattern. Debbie has been lawfully admitted for permanent residence in the United States and is domiciled in Texas, the same place where our plaintiff is a citizen. Pam brings a state law tort claim against Doug and Debbie in federal court. Does complete diversity exist between the parties? So if we diagram it out, we have a plaintiff who's a citizen of Texas suing a defendant who is a citizen of Florida, and another defendant who's a citizen of Mexico who has permanent legal resident status in the United States and is domiciled in Texas. So because our defendant is a resident, because our defendant here, defendant 2, is a citizen of Mexico, a foreign state, because that defendant is an additional party to an action between U.S. citizens from different states, basically that exception, that permanent resident exception from 1332A2 is not applied. Basically, we just ignore the defendant from Mexico for diversity purposes in this analysis. Therefore, complete diversity exists. Okay, hopefully that makes sense. When we have this situation where the foreign party is a third wheel, it's an additional party to a lawsuit that looks like 1332A1. It's just a lawsuit between plaintiffs and defendants from the United States who are diverse. But then we have this added in third party, this additional party from a foreign state. Okay, well, we ignore it in that case. We basically just cross them out of the analysis because they're an additional party. That permanent legal residence and where they're domiciled, it's all irrelevant. That exception only applies to 1332A2, where the foreign party is not an additional party. They're not a third wheel. They're like the main party. We have a plaintiff from the United States suing a defendant from Mexico. Right, that's where 1332A2 is triggered. But when we get in this situation where the foreign party is a third wheel, right, that's where we ignore the exception from 1332A2. We basically, for purposes of this analysis, just remove the foreign party from the analysis. So we would just cover it up and ask, does diversity exist? Right, on our diagram, we would just basically cover up the defendant from Mexico, and we'd have a plaintiff who's a citizen of Texas suing a defendant who's a citizen of Florida. Obviously, complete diversity exists. So really, this whole analysis between 1332A2 and 1332A3 comes down to whether the foreign party is an additional party. If the foreign party is this third wheel additional party, the exception does not apply. It doesn't matter where they're domiciled, if they have permanent resident status or not. It's just not a part of the analysis. But if the foreign party is not an additional party, they're like a quote unquote, what I'm calling main party, right? Basically, it's not an action between citizens of the United States that are diverse, and then we just have this third party. It's, plaintiff from Texas suing defendant from Mexico. That's more like 1332A2, and there that permanent residence exception does apply. We actually have to look at, okay, if that foreign party is a permanent resident, where are they domiciled? If that's the same place as any of the opposing parties are citizens, that state citizenship is shared, then it destroys complete diversity. Okay, that's 1332A2 and A3. I know it's a little bit confusing it's one of those things that's kind of hard to talk through out loud, but if you just write it down and work through the examples, I think it'll become clear. So go over that outline, look at the examples, rework, pause the video, go back, rewatch those hypotheticals and work through them. It'll start to click. Okay, sometimes it's hard to talk through some of these things. You got to just see it on the page. Okay, it takes our last one here, our last subsection under 1332A. We have complete diversity under section 1332A4. Here we say complete diversity exists when at the time the complaint is filed, the action is between a foreign state as plaintiff and citizens of a U.S. state or of different states. This is very straightforward. This would be like the actual Mexican government itself suing defendants of the United States. So it doesn't matter if the defendants are from the same state or different states. In this case, complete diversity exists. That's 1332A4. And that's where you would see literally a foreign country's government, like the Mexican government, is suing defendants of the United States. In that case, okay, that's A4, section 1332A4. Complete diversity is present. I think it's fairly rare you would see that tested, but if you do, there you go. I would diagram it like we have here on this slide. You have complete diversity in that situation. Okay, this now, if we understand 1332A1 through 1332A4, right, the big question is, to this point, we've been stipulating the citizenship of the parties. I've just been telling you, this person's a citizen of Texas, this person's a citizen of Florida. On the actual bar exam or on a law school final exam, you actually have to determine the citizenship of the parties. It might not be stipulated. So you have to understand at the time that complaint is filed, you have to know how to actually determine the citizenship of each party, of each plaintiff and each defendant. So how do you do that? Well, it depends on basically the classification of each party. We'll see the rules change a little bit depending on whether the plaintiff or defendant, the party to the lawsuit, is an individual, a corporation, an unincorporated association, or a Rule 23 class action lawsuit. Okay, so let's just break each of these down. Let's start with the big two, which is individuals, sometimes called natural persons, and corporations. How do we determine citizenship for these types of parties? These are the big two we want to think about. For individuals, or what sometimes you'll hear courts refer to as natural persons, it's the state of domicile. Basically, an individual is deemed to be a citizen of the state where they are domiciled. An individual's state of domicile, it's the state where he concurrently establishes physical residence with an intent to remain there indefinitely. Domicile, for the most part, is somewhat easy to establish on fact patterns, right? It's that physical residence with an intent to remain there indefinitely. It's basically where a person lives. Important to note here, a person can only have one domicile at a time. You can't have a domicile for diversity purposes in 10 different states. You only get one. It's the place where a person concurrently establishes physical residence with the intent to remain there indefinitely. So in real life, intent to remain in a place indefinitely can be a complicated issue. Usually a court is going to have to use circumstantial evidence to try to determine what a person's intent is. They're going to look at, well, where's this person work? Where do they go to school? Where's their driver's license? They have to look at all of this evidence to try to figure out what a person's intent is. Did they have the intent to remain in a place indefinitely or not? Were they planning on moving or were they in the process of moving? Had they moved somewhere? Where do they concurrently have physical residence with an intent to remain there indefinitely? Okay. And again, in real life can be complicated. Most of the time in law school and bar exam fact patterns, this is given to you. The intent of the party is usually kind of stipulated in the facts. This is a nice thing about imaginary fact patterns. In real life, it's hard to get in somebody's head, right? Unless they confess what their intent is. Otherwise, generally courts have to use circumstantial evidence to try to determine the intent of a party. But for our purposes, a lot of time you're going to be given that intent. So you're looking basically for the concurrent establishment of physical residence with an intent to remain there indefinitely. That's how you determine where a person's state of domicile is. Remember, you can only have one domicile at a time. Very important, right? You can't have 10, you get one domicile. So individuals, natural persons, can only have one state citizenship at a time. You cannot, for diversity purposes, be a citizen of Texas and Florida at the same time. An individual cannot have dual citizenship for diversity purposes. Corporations do have dual citizenship for diversity purposes. We say corporations are deemed to be citizens of their state of incorporation and the state of their principal place of business. Okay, so corporations are going to have two citizenships or citizens of basically two states at the same time. It is possible the state of incorporation could be the same state where the corporation has its principal place of business. In that case, the corporation would only have citizenship in one state, but most of the time we see corporations have dual citizenship. Often we see corporations incorporate in the state of Delaware because there's perceived benefits to being incorporated in the state of Delaware, and they might have their principal place of business somewhere else. And we'll talk about what the principal place of business is. Courts use the nerve center test to determine the state or country where the corporation's principal place of business is located. What is the nerve center test? This comes from Hertz Corp v. Friend, a very famous civil procedure Supreme Court decision. In Hertz Corp v. Friend, the Supreme Court articulated a corporation's principal place of business, in other words, the nerve center of the corporation, as the place where a corporation's officers direct, control, and coordinate the corporation's activities. It should normally be the place where the corporation maintains its headquarters, provided that the headquarters is the actual center of direction, control, and coordination, and not simply an office where the corporation holds its board meetings. So the big thing I think about here always with the nerve center test, I keep DCC in my head: direct, control, and coordinate. It's the headquarters where the corporation's officers direct, control, and coordinate the corporation's activities. Those are the buzzwords: DCC, direct, control, and coordinate. So the principal place of business is usually where the corporation's headquarters are, where those upper level managers are directing, coordinating, and controlling the activities of the business. It's not a place where they have quarterly, shareholder meetings or something. It's the place where the headquarters are, where those officers, those upper level managers, that C-suite team is directing, controlling, and coordinating the activities of the business. Okay, this is the nerve center test. Okay, so we know corporations have dual citizenship. State of incorporation, a lot of times this is Delaware. And by the way, state of incorporation is like a legally ascertainable fact. This will be given to you in the fact pattern. They will just be told, hey, the articles of incorporation were filed in this state. Okay, that's the state of incorporation. So we know the corporation has citizenship there. The other place where they're going to have citizenship is the nerve center test, where their principal place of business is located. And that's going to be the headquarters where the officers are DCCing, directing, controlling, and coordinating the activities of the business. So let's look at some basic fact patterns, okay, just based on what we talked about. Let's go to practice problem 4.0. Okay, part 1. This practice problem, we're actually going to kind of continue in multiple steps, but let's just look at the first part here. Pam lives in an apartment in Virginia and has no intention of moving. However, she has been accepted to a university that is located in North Carolina. In an attempt to take advantage of in-state tuition at the university, Pam rents a second apartment in North Carolina and uses this new address to obtain a valid driver's license in North Carolina. Once Pam obtains the North Carolina driver's license, she files an action in federal court. Where would the court deem Pam to be a citizen for diversity purposes? So we look at the time the complaint is filed, right? We're trying to determine at the time she files that action in federal court, where is Pam a citizen for diversity purposes? Well, Pam is a natural person. She's an individual. She's not a corporation, right? She's not some unincorporated, member of some class. She's not in this isn't a class action lawsuit. She's just an individual, natural person filing a lawsuit. So how do we determine her citizenship? It's domicile. It's the place she lives with an intent to remain indefinitely. Where's that physical residence with an intent to remain indefinitely? Well, it gives it to us in the first sentence. Pam lives in an apartment in Virginia and has no intention of moving. Okay, and then nothing in this fact pattern really tells us that she gains an intent to leave. She never changes her physical residence concurrently with an intent to remain in the new place indefinitely. In fact, to the contrary, we see her intent, this whole thing with North Carolina, right? So she lives in an apartment in Virginia and has no intention of moving. So first sentence, we can establish, all right, she's domiciled in Virginia. Does anything happen that would change her domicile as we work through this fact pattern? The answer is no. Right? Obviously, she's just trying to get in-state tuition. So this whole thing about getting a second apartment in North Carolina and using this address to get a driver's license, this is not her having the intent to actually move, to remain in North Carolina indefinitely. She's just doing this to try to get in-state tuition. That would not be sufficient to actually change her domicile or her citizenship for diversity purposes. So the answer here is Pam is a citizen of Virginia for diversity purposes. We can go to the next part of this practice problem. So let's continue along. Okay, Pam needs a car to make the commute from her apartment in Virginia to the university in North Carolina. Pam enters into a contract to purchase a car from Auto Company, a business incorporated in Delaware. Auto Company conducts most of its business operations in North Carolina. However, upper-level management directs and controls the company's activities at its headquarters in Virginia. Pam pays Auto Company for the car, but never receives it. Pam brings a state law breach of contract claim against Auto Company in federal court. Where would the court deem Auto Company to be a citizen for diversity purposes? Well, the court's going to go, at the time the complaint was filed, where was Auto Company a citizen? Well, Auto Company, we see, is incorporated in the state of Delaware. So we assume, or we know, we don't have to assume, if they're incorporated, that means they're a corporation. If they're incorporated in Delaware, we know they have citizenship in Delaware, right? Corporations have dual citizenship. the state of incorporation and the state where their principal place of business is located. So we have the first one. We know Delaware is one place that it has citizenship, but we know corporations, auto company, is dual citizenship. So we have to determine what's its principal place of business based on these facts. Basically, we apply the nerve center test. Remember, DCC. Where does the company have its headquarters where upper level management directs, controls, and coordinates the activities of the business? We see here that is in Virginia. Even though auto company conducts most of its business operations in North Carolina, maybe it's got all of its dealerships, its sales pipelines, its whatever, is all happening in North Carolina. Okay, so like all of the revenue is being generated in North Carolina, all the operations could be there. We could have all these facts about North Carolina. But as long as upper level management is directing, controlling, and coordinating the activities at headquarters located in Virginia, nerve center test says its principal place of business is Virginia. Therefore, our answer here, where would the court deem auto company to be a citizen for diversity purposes? They have dual citizenship in the state of incorporation, a state where the principal place of business is located. That's going to be Delaware and Virginia. Okay, so let's finish this practice problem out to part 3. So now we know, considering Pam is a citizen of Virginia and auto company is a citizen of Delaware and Virginia, does the federal court have subject matter jurisdiction over the state law breach of contract action? Well, remember, if we're being asked, does a federal court have subject matter jurisdiction? We know, well, federal courts are limited in subject matter jurisdiction. They're limited in the types of cases they can hear. What are those cases they can hear again? Remember, the big 4: federal question jurisdiction, diversity jurisdiction, supplemental jurisdiction, removal. And we always start with federal question and diversity. This is a state law breach of contract action. It does not arise under federal law, so the federal court does not have federal question jurisdiction over the case. Does the court have diversity jurisdiction over the case? Well, we diagram it out, right? Step 1, to have diversity jurisdiction, we know complete diversity must be present and the amount in controversy must exceed $75,000. Let's diagram it out to determine whether we have complete diversity between the parties. So plaintiff here is a citizen of Virginia. Our plaintiff Pam is a citizen of Virginia. And our defendant auto company is a dual citizen in Delaware and Virginia. Okay, so we have a plaintiff that shares citizenship with a defendant in Virginia. Complete diversity does not exist. So the federal court cannot have diversity jurisdiction over the case. So the federal court does not have federal question jurisdiction, does not have diversity jurisdiction. We don't need to worry about supplemental jurisdiction removal. At this point, we can say here, okay, that federal court does not have subject matter jurisdiction to hear this case. It's not the type of case a federal court can hear because it doesn't have federal question jurisdiction. It does not have diversity jurisdiction. Okay, we've now worked through like a full fact pattern, something you might see on a law school exam or the bar exam, kind of applying everything. All right, one other nuance here we need to go over. Determining citizenship for diversity purposes, we just went over individuals or natural persons and corporations. There are 2 other classes we need to think about. We have unincorporated associations and Rule 23 class actions. We say for unincorporated associations, this would be things like labor unions, limited liability companies, really any, organization of people that has not been incorporated, that has not filed their articles of incorporation to become a corporation. Limited liability companies, labor unions, partnerships, the main types of things you see here as unincorporated associations. We say an unincorporated association is deemed to be a citizen in every state of which any partner or member is a citizen. Generally, the partners and members of an unincorporated association are going to be natural persons, individuals. So we just look at the domicile of every partner or member in that unincorporated association. That's the citizenship. So an unincorporated association can be a citizen in all 50 states. If it's got 50 members and every single member is from a different state, all 50 states, then that unincorporated association is a citizen of all 50 states. Okay, that's just how it works. Rule 23 class actions are deemed to be a citizen in every state of which any non-absentee representative party is a citizen. Without getting into too much detail on Rule 23 of the Federal Rules of Civil Procedure, it's important to note under Rule 23, when we're thinking about a class action lawsuit, you have representative parties, basically the parties who are representing the class, and everyone else who's not a representative party, we call an absentee member of the class. For diversity purposes, when we're determining citizenship of a Rule 23 class action, Rule 23 class for diversity purposes, it's every state of which any non-absentee representative party is a citizen. So we just look at the representative parties. And again, this is usually natural persons. So it's the domicile of every representative party of that Rule 23 class. That's what we say the citizenship is for the class as a whole. So let's go over an example here. We go to practice problem 5.0. Let's say a class of 2,500 people bring a state law tort class action against Acme LLC, a limited liability company, an unincorporated association, in federal court. The individual members of the class of 2,500 people are domiciled across 5 states, state A, B, C, D, and E. However, all of the members of the class are represented by Pam, pursuant to Rule 23 of the Federal Rules of Civil Procedure. Pam is domiciled in state A. Acme LLC has 4 members, Doug, Dan, Debbie, and Diane. Acme LLC's members are citizens of state B, C, D, and A, respectively. Does complete diversity exist? The answer here is no. The class and Acme LLC share citizenship in state A. Let's diagram this out, okay? Practice problem 5.0, continuing, we say here, the class is a citizen of state A because Pam, a citizen of state A, is the only representative party of the class. The citizenships of the remaining absent members of the class are excluded for diversity purposes. So even though our class had 2,500 people, probably from all different states, because the class of 2,500 people is only represented by Pam, the other 2,499 members are considered absent. Their citizenships are excluded when we're thinking about the citizenship of the class as a whole. For diversity purposes, we only look at the representative parties, not the absentee members. Here, the representative party is Pam, and she's domiciled in state A. So with the entire class is a citizen of state A. Okay, Acme LLC, on the other hand, is an unincorporated association. Remember, corporations have to be incorporated. LLCs do not file articles of incorporation. They're considered unincorporated associations. Acme LLC is a citizen of state B, C, D, and A because these are the states of which its members, Doug, Dan, Debbie, and Diane, are citizens. Okay, so if we know all of this, we can just diagram it out. Left side of the arrow and right side of the arrow, then we play a matching game. So we know our class, represented by Pam, is a citizen of state A, suing our defendant, Acme LLC, an unincorporated association. And we know that unincorporated association is a citizen in 4 states because it's got 4 members and each member is from a different state. Each member is domiciled in a different state. B, state B, state C, state D, and state A. So because Diane is domiciled in state A and Pam is domiciled in state A, complete diversity is destroyed. Pam is representing that Rule 23 class. She's domiciled in state A. That makes the class a citizen of state A. Unincorporated associations are citizens where all their members are domiciled. So here, Acme LLC, because Diane is domiciled in state A, it is a citizen of state A along with state B, C, and D. But because we have state A on both sides of the arrow, we have our plaintiff and defendant sharing citizenship in state A. This destroys complete diversity. So to answer our question, no, complete diversity does not exist because the class and Acme LLC share citizenship in state A. Okay, so this is everything we need to cover for the diversity requirement. If we're looking at a fact pattern and we're trying to determine whether complete diversity exists, remember step one, we fast forward to the time in the fact pattern where the action is filed. We go, where was the complaint filed? At that moment in time, where is each party in this lawsuit a citizen? Remember, determining citizenship depends on the classification of the party. Natural person, is it an individual, natural person, corporation, unincorporated association, or potentially a Rule 23 class action situation? We apply the rules we just discussed for each. Obviously, an individual or natural person, it's the state of domicile. Corporations have dual citizenship, state of incorporation, and state where its principal place of business is located. Unincorporated associations, it's where all the members or partners are domiciled, so it can be like all 50 states. Rule 23 class actions are the representative parties. We exclude the absentee members. Where are those representative parties of the class domiciled? Okay, that's going to give us the citizenship of that Rule 23 class. Once we determine the citizenship of each party at the time the complaint was filed, we just diagram it out. Put all our plaintiffs on the left side of the arrow, all our defendants on the right side of the arrow, match it up. Do we have a match on the left side and the right? If we have a match, then that means one of our plaintiffs shares citizenship with one of our defendants. One of our plaintiffs shares citizenship with one of our defendants. That destroys complete diversity. And remember, we have those nuances. If we have a foreign party involved, you can go back and rewatch that to see how we deal with the situation where we have a foreign party involved. It really just comes down to whether that foreign party is an additional party or not. If it's an additional party, remember, we almost just ignore them and do the same diversity analysis we've been doing. If that foreign party is not an additional party, it's like a main party, so to speak, remember, we have that permanent resident exception we have to deal with. Otherwise, that is the complete diversity analysis. Remember though, complete diversity is only our first requirement under Section 1332. Under 28 U.S. Code, Section 1332, a federal court has diversity jurisdiction if number one, complete diversity is present, and number two, the amount in controversy exceeds $75,000. So from here in our next lesson, part 2 of our diversity jurisdiction series here, we're going to get into the amount in controversy requirement. But until then, guys, I do wish you all the absolute best, and I'll see you at our next lesson.